Welcome to the Estate Planning Podcast. I'm Bill Gross, and we do this program regularly to interview and meet some of the top professionals, both in estate planning and related fields, vendors, and such. We're excited to have a longtime friend, colleague, more importantly, an attorney who is probably an expert on mistakes to avoid in your estate planning process. Our attorney, Jack LaPedis. Jack, thanks so much for taking time for us today.
Thanks for having me. Good to see you again.
On one hand, great respect for you and your practice. On the other hand, you're a UCLA fan. I don't know how those two things can both sit in my head at the same time, but we're going to try to ignore that, move forward, okay?
We'll see what we can do.
And full disclosure, he's an attorney in California, so his legal advice obviously is most germane. But I think the general rule is the principles are similar throughout all the states. Not to say you would take that as law, but these are things to think about and maybe ask your attorney or talk to your clients about if you're an attorney about these issues. So, Jack, before we start, we did kind of list a couple of the most common estate planning mistakes or estate not planning mistakes. And we listed a couple together. One was transferring a property to a family member without the right plan in place. Talk about that a little bit.
Yeah, so my practice focuses mostly on real estate disputes. So purchase and sale disputes, disputes with real estate professionals, neighbor disputes, things like that. But and I've been an attorney for 29 years, and more than half of that I've been dealing with real estate. So my view on this comes from the standpoint of a real estate litigation attorney. I don't do estate planning, but a lot of these estate planning issues show up in my practice. And that's where I'm coming from when I talk about these mistakes that people make that eventually end up on my desk. So one of them, a big one, is not just transferring a property to a family member. But really what a lot of people try and do is, we've been in the family home for many years, and I have adult child or adult children, and I'm going to add my child to title on the family home.
Makes sense. That way, why not? What could be wrong with that?
Right. That way, when I die, they're already an owner. And so I won't have to go through probate or whatever reasoning there is. Mm-hmm. It's a terrible idea. And estate planning attorneys will tell you that as well. One of the first problems with that is that it may trigger a reassessment. So you may have owned this house for a long time and have very favorable tax terms. But once you change the ownership status, even if it's just to add somebody, you're not changing anything but adding, that may trigger a reassessment. And then you've really screwed up the taxes on the property. I'm going to take a breath to let you jump in.
Yeah, just to clarify, so reassessment of property taxes.
Yeah.
And in California, the common challenge is that mom and dad can have a house for 30, 40 years, like in my neighborhood, and have a $2 million house that they're paying $800 a year of property taxes. And if it's reassessed that the transferee is a new owner, at 1% plus, it could be $22,000, $23,000 a year difference every year based on the difference in property taxes.
Right. And that, and I don't do taxes either. This is not tax advice. This is just stuff that I've seen come across my desk. So that's the first thing that causes a problem. The second thing is that if your child is on, your adult child's on title and they get sued, they have this asset that is your house that can be, a judgment can be attached to, and you can lose the house to that judgment. That's pretty cut and dry of a problem.
Right. Right. So, and the younger you are, more likely you are to be sued because you're doing more stuff. Someone might be retired and you're around the home more, and your business, maybe you're in retirement, and your child is in business or working or out in the world, doesn't have insurance on their car. Next thing you know, the first thing an attorney does is sees what assets that person has. And if they see they're co-named on the property, boom, they're going to put a lien on that property and do their best to get a hold of it.
Right. And there's also the issue with, and this one is I only know from 30,000 feet, which is basically when you pass away, your child gets what's called a step-up basis, which means it's like they bought the house the day you died. So when they go to sell the house, the taxes is only on that. Uh, the word escapes me, but the difference between what you bought it for and what you sold it for, your profit
Right.
essentially, gets taxed.
Right.
Well, if you pass away and your child inherits the house, it's like they bought it that day. And if they turn around and sell it the next week, they will have their taxes will be a lot less than if you transfer it to them and they're an owner and they don't get that stepped up basis. And so when they go to sell it, they're going to have to pay, if you bought it 30 years ago for $40,000 and you're selling it for $1 million, it's a lot of taxes. So that's another one I heard about.
I think, and I'm not giving tax advice either, but I'm involved with this. I've also been the recipient end. Any heir gets it at a step up, meaning we do a day of death tax, a day of death appraisal, and we do one when the property is transferred. But the estate doesn't pay taxes, and the recipient, the heir, regardless, a child or not child, the heir gets the property at the stepped up basis. It kind of evaporates that capital gain. And so
right. Capital gains, that's the word I was looking for. Thank you.
So if you hold it for 10 more years, then now you have 10 more years of appreciation versus if you got 10 years later when they pass, you're paying taxes on that days. But if you buy it 10 years, if you got add on the deed 10 years prior, when the property's worth 1 million, you're now going to pay taxes on the difference between the million and the 2 million. And that's where the problem comes to play. If they give you the whole property, then you're liable for the whole increase in time. Yeah, so that's a big one. So family members transfers will possibly trigger reassessments and will also expose them to liability possibly, and will also lose on the opportunity for the free step up.
Right. And I also want to add to the liability sort of a subset of that, which is your adult child takes out a loan and uses the house as collateral because they can.
Right.
And you also, another minor thing is if someone's on title, they have a right to possess the property, which means they can live there. And there's nothing you can do about it. And, everyone has different relationships between the parents and kids. If the kid is on title, then they can live there rent free, which you may or may not want. But if they're not on title, you have much more control over that sort of thing.
Okay. So transferring to family member, I think your advice is get proper legal advice to make sure what you're doing will accomplish your goals and not bring along a bag of problems that you don't want.
Yeah, I mean, almost all the time from my conversations with estate planning attorneys and what I've seen come across my desk, almost every house, at least in California, should be in a trust.
Yes.
And if you're the parent, the owner of the house, you're the trustee, and your kids are beneficiaries, and that's the proper way to move things through, especially if you want to avoid probate. And you can put in that trust whatever limitations or whatever you want so that your desires get passed down.
Right.
And a estate planning attorney a good estate planning attorney will help walk you through that.
Yeah, the motivation for transfer family members, one's to avoid probate, which doesn't really work because of the problems you've identified. The other one is to lower their assets because they're trying to qualify for a means-tested program, meaning one that's based on your income or assets. And there are more suitable solutions than just giving the property to somebody. The other part that gets overlooked also is it might trigger a tax because a gift over a certain amount theoretically is supposed to be reported, and the recipient has tax consequences possibly as well. Not saying they do. Talk to your attorney and get that advice. But there are estate planning attorneys we've interviewed who have ways to put it into a trust that will qualify for means-tested programs and still keep control in the hands of the parents.
Right. One thing to always keep in mind when it comes to the law is that the law is absolutely a double-edged sword. For every benefit, there's a negative. And a a lot of people seem to want to ignore that fact. It's, oh, I'm going to do this and I'm going to put it in my, my mother-in-law's name. And so blah, blah, blah. But now technically you don't own it anymore. Your mother-in-law does. And you're,
Right.
so there's that, all those sort of things come up. And another thing to keep in mind is people who get upset at their attorneys who keep telling them things they can't do. You don't hire an attorney to tell you everything that could go right. That's not an attorney's job.
That's an interesting one. I never heard that one before. Makes sense though, right? You want the attorney to tell you all the things that can go wrong and how to avoid those that are appropriate to avoid and how to deal with the ones you have to deal with.
I don't like
Okay.
to use the term. I don't like to use the term avoid. I like to use the term like decrease the risk, because
Okay.
there's no avoiding 100% avoiding things. There's no slam dunks. LeBron James misses slam dunks. There's no slam dunks in the law.
Whoa. LeBron James misses slam dunks? I don't think I've ever seen that before.
And I love it every time. Go Warriors.
Well, and I don't go as many basketball games as you do. In fact, I don't think anybody does. I don't think the owner of the Lakers, Jeannie Buss, I don't think she goes as many games as you do with your family. That's a whole another discussion. Okay, so transferring family members, fraught with potential alligators, consult an attorney, consult Jack or somebody appropriate before you willy-nilly change just because you're solving a problem. You might be creating an equal or bigger problem on the other end. That's one area to talk about. The second we want to talk about is buying with a non-family member. So I commonly see people who buy with, oh, my girlfriend, but we're like married. We're like married. We're going to always be together. Or my brother and I buy property together. We're brothers. Our whole lives we've been brothers. We're going to be brothers forever. We're going to love each other and communicate effectively forever. Or a partner. Hey, we found the property together. He didn't have to work. I didn't have to work. What could possibly go wrong buying the property with somebody that you're not married to or not a family member, or even there, of course, there's other issues. But let's say in particular, what kind of unique issues are there buying with people that you're not related to?
So this is very specific. If you are buying property with someone who is not your legal, put a ring on it, spouse, okay?
Uh-oh.
You need to have some sort of agreement. Sometimes it's called an operating agreement. And what that agreement says is, when this happens, this is what we're going to do. Or
Right.
if a decision needs to be made, this is how the decision is going to be made. Or another big one, you buy a piece of property with your best friend from kindergarten. This is your best buddy. You've been friends with him forever. You guys have
Ever.
never fought.
Never
Okay?
fought.
You agree on everything. You buy this piece of property, and God forbid your friend dies. Now you're in business with his wife, right?
Yeah.
Now you have conflicts. You don't see eye to eye, or she needs money. She wants to sell the property, that sort of thing. So you need an agreement that says, what happens if someone dies? What happens if someone wants to get out of the deal?
Right.
How do you determine whether the property gets sold? How do you determine the value of the property if one party is going to buy out the other? How do you determine how much is going to be invested in the property if you need more capital? All the things that you do with property, all the decisions that need to be made, if you are in a partnership with someone who's not your spouse, because a spouse is a totally different legal animal. If it's not your spouse,
Whoa, you call my
need
wife
an
an
agreement.
animal?
Yeah, I'm sorry, I've never met your wife.
Okay. She might be. She's not here, so.
Yeah. So I mean, and it sounds perfectly logical and reasonable, but I can't tell you how many times I have handled ugly divorces of business partners, and business partners who were brothers, business partners who grew up together, boyfriend and girlfriend, and boyfriends and girlfriends break up, husband and wives break up, but there's a whole area of law that covers husbands and wives breaking up. There isn't really for boyfriends and girlfriends when it comes to real estate like this.
And then it becomes like our legal tug of war.
Yeah, and there's it's unfortunately, as with a lot of things, the only people that come out ahead are the lawyers. And I'm here to tell you, I'm one of those lawyers that I wish people didn't need me, and I feel bad when they come to me. If they had come to me a year earlier, 2 years earlier, before they made a decision. That's why when I go to a lot of my networking groups, I tell people, before you sign something, talk to a lawyer, whether it's me or someone else, and before you make a decision that you're bound to, it makes a lot of sense to talk to a trusted advisor like a lawyer.
I took a perfect case study. I have a state that I'm the realtor for. The guy was a very sophisticated real estate investor. He had one partner who owned four properties with him. One of the properties they had an operating agreement on, and the partner doesn't like the terms of the operating agreement. But as I said to him, you have to like it. You're just bound by it legally. And the other three didn't have it, and it's been a very difficult process. And I had to explain to him that the heir in this case was a son who had a military career, couldn't afford to be in business with this partner because this partnership included property with cannabis. And for whatever reasons, for a security clearance, it wasn't appropriate for him to own rental property in California with cannabis tenants. And that's his privilege. And I said, you went from somebody who's a very sophisticated investor who loved these kind of properties to somebody who can't own them. They don't have a choice. They're going to sell them. Doesn't matter what you say. They're going to hire whatever terms it takes to sell the property. And it's difficult. There's also a common case of a friend who called me who she was living with her mate. They just never got married, and then they fell apart, and she wanted to get the property sold because the other guy was on the mortgage and in control of it. And it can be difficult, and that's where you need an attorney, I think, to help you probably in this case, force the sale, because she just wasn't willing to allow him to have control. But so all of these without a written agreement is one thing, but also even with the written agreement, we have another property where there is a written agreement and the partner just doesn't like the terms of it. And so he's hired an attorney to defend himself. And the attorney called me and I said, well, this is the agreement. I understand. What is your grounds for fighting this? So,
that's why you need to get a good agreement. That's why you don't want to pull it offline or, write it yourself or do something like that. You actually want to hire a lawyer who writes these agreements and knows what stands up in court and what doesn't.
Right.
That's one of the things that I've learned over the years is it's one thing to put something into an agreement the way that you and your partner or whatever want it. It's a whole nother thing to put something in an agreement that a lawyer knows will hold up in court.
Right.
And you got to merge those two things, what you want to say and what's going to hold up in court. Because, I've had situations where a client came to me and said, my business partner on this property is trying to force us to sell or whatever. And I know for a fact that this business partner has been shopping the case around because they had an operating agreement. I didn't happen to write it, but it was a very good agreement. And he could not find a lawyer to try and break the agreement because it was a well-written agreement. And we were able to have a favorable result for my client because we were able to make him stick to the agreement.
Nice. Another area that we talked about for estate planning common mistakes is probably not preparing your children, maybe adult children, right? It's one thing to have an estate plan when you have young children to provide for them in case something goes wrong. But even as your children become a majority and go out in the world on their own, what kind of advice do you have there? What sorts of strategies do you recommend for people, or what mistakes you see people not making?
So I have two young adult children. They're both in their early 20s. And when they're both older students in the sense that they were always older than the kids in their class. There's always a few kids who are super young. My kids were always in the super older. So they both turned 18 when they were in high school. And when it came around that they were getting towards 18, it dawned on me some of these things that come up with estate planning and such. And so I reached out to an estate planning attorney colleague of mine and hired her to be first was our daughter, be my daughter's estate planning attorney. And we talked about what kind of documents we needed. We put together medical releases so that me and my wife could assist our daughter should something happen to her once she turns 18. We That includes a HIPAA release that I have on my phone and my wife has on her phone. And I also have the original hard copies. Um, Now, this isn't so much in high school, though we did it anyway, but school record releases. I mean, even though we were paying for her schooling, they're her records. And though a lot of schools will just give out the records to parents, you just have to run into that one administrator,
Right.
or like at a hospital, you're just like, oh, it's my daughter. She's in high school. Of course, the doctor is going to let me know what's going on and make decisions, but you only have to run into that one doctor, or that one hospital administrator, or that one hospital lawyer who's like, she's 18, she's an adult, you don't get to make the decisions. So there's other documents. We also put together a trust and a will, even though they don't really have any assets, but it's just something that it's there so that once they start acquiring assets, they don't have to sort of start over. Right. Once they have partners and they get married, they're going to have to change those so that instead of me and my wife being the beneficiaries, they'll set something up with their spouse. But again, you don't hire a lawyer to tell you everything that's going to go right. I think about all the things that could go wrong. And I actually, way, way, way back in my career, I practiced in medical malpractice defense. So I represented doctors and hospitals and such. And I remember there being cases where there was some question about whether information was going to be released regarding an adult child to their parents.
Right.
And that kind of stuck with me. And it really does happen. And you're like, oh, there's millions of people who go to the hospital every year or whatever you want. But if it happens to you, it doesn't really matter how many other people it didn't happen to.
I had an aunt who had a long time quasi-spouse relationship. She had a divorce where she would lose spouse support if she remarried. So she found a man, and they lived like their husband and wife, but never got married for that reason. And she actually told the hospital she gave the advance directives to the hospital for medical decisions and records. But what she didn't do was ever get the financial records because they kept separate, whatever reason. And he was trying to, my uncle, quasi-uncle, was trying to prove that certain insurance was paid, but because he didn't have access to her bank records, he couldn't prove it. So here she's in the hospital waiting for a certain authority. And even though she'd given medical directives, it affects the medical care. And he wasn't the spouse. He didn't have the privilege at this one bank. And like you say, it just takes one of this whole chain of people. One person has to step and say, no, I'm not going to recognize that relationship. And these things are getting more and more complicated. So obviously, the more we can plan ahead and prepare as best we can limit the risks and limit the choices.
You know what? You brought up a really good point. I unfortunately went through a situation about 12 years ago. I have an uncle who lived in Southern California, one of my only relatives that lived down here, and he became very ill. And I was able to put together a power of attorney, and I had a notary come in, and I had the notary meet with him without me there to discuss, make sure he knew what he was doing. Got it notarized, so I had a power of attorney, and one of his banks would not honor that power of attorney. They said it has to be on our form.
Yeah.
And I actually ended up on the phone with their general counsel of this bank, telling him, like, I need to have access to this bank so I can pay his rent. And I mean, it was, I could probably pay it, but I God forbid something happened to him and I needed these funds. And they really dug in their heels. They were like, no, it needs to be on our form. And I said, well, that ship has sailed. I have a legally binding document here. And they really dug in. So that's another thing to look into is your financial institutions. Make sure you have people set up as beneficiaries. Make sure you have people set up as, powers of attorney if necessary, that sort of thing. And, most people don't figure out their burial arrangements because they don't like to think about that. But, these are the things you got to think about. How are people going to get to your bank account if you're incapacitated?
Yeah. We had a probate case where Chase Bank, who's the private banker to Jeffrey Epstein's sex trafficking operation, paid millions of dollars twice, took over a bank, First Republic, that my client had money in. And even though we had a court authorized administrator, letters of authority, they wanted the court to write a specific order authorizing them to make a transfer. And we ended up, the estate ended up suing them and settling for about $25,000 in penalties, all the interest lost and all the court costs and all that. And it's almost like the Chase attorney was fine making that decision because, he was working and he got paid either way. The fact that drove our estate crazy and we're almost defaulting on clients and people aren't getting rent and employees aren't getting payroll, they could care less. So I just think that the more of this, and I'm not sure there's anything that we could have done to prevent it. I'm just saying that these administrators and bankers, every year, in my experience, I'm 66, every year, service at these organizations, governmental and non-governmental, get worse and worse and worse. And you have to do more just to stay even and don't give them a chance to say no. And so good, proper estate planning, getting paperwork set up ahead of time as much as you can, at least it limits the fights you're going to have, and hopefully the ones you have left you can win. So, Jack, look, I know you do more than just estate planning and cleaning up problems. We talk about real estate issues with you all the time, lot line issues, disputes over neighbors, noisy neighbors, threatening neighbors, things like that. If someone want to get a hold of you and talk about legal issues of real estate and or estate planning, what's the best way to get a hold of you?
You can reach me through my website, lapedislaw.com, LAPEDISLAW.com. Woo.
Yeah, that was kind of wild, huh? Let's get the right one up there. I'm sorry about
that. So you can reach me through there, and if you search around online, you might find me on some of the social media websites. That's probably a good place to get.
And I know I see Jack at a real estate networking event in Van Nuys on Wednesdays. He's very active in our local real estate community, and I appreciate his support. And then for those of you who are watching, that's Jack LaPedis. Get his contact info, lapedislaw.com. This is the Estate Planning Podcast. We're on Facebook. Feel free to continue the conversation there, ask questions. If you're looking for referrals for real estate agents, for attorneys, other states, other areas, feel free to post them there. We'd love to have you support. Jack, as always, you've been a great support of my business all along and the real estate community in general. Thanks for your support. I really appreciate it.
Oh, thanks for having me. I really appreciate it. Always love talking with you, Bill.
Thanks. And for the rest of you, I'm Bill Gross, at Bill Gross Probate and social media. This is the Estate Planning Podcast. We issue a new episode every week. We have attorneys and important vendors in the business. And if you have questions, feel free to ask them, subscribe. If I can help, please reach out, send an email or text. As always, make today your best day ever.